Donald Trump objects to Jack Smith's jury questionnaire. We know that trial is not scheduled for quite some time in Florida, and it might move, but Jack Smith wants to pick up the pace like right now. He wants the jury questionnaire to be assembled and go out, and Trump is saying, what? I haven't even reviewed all the discovery yet, so how would I even know what to put on the jury questionnaire? So Jack Smith is asking Judge Cannon for permission to do this. Trump is responding saying, how dare you? And he's actually asking Judge Cannon to tell them to knock this crap off, saying they are trying to mess with this litigation by jumping ahead in the schedule. Judge, you've already issued a schedule on this, so let's just stick to that one. So the objection comes, and we're going to take some reaction from Nikki Haley and from Bill Barr, because Nikki Haley's just ignoring all of this, because if Trump gets removed, maybe she slots in the number one position. But this is what Jack Smith is referring to when he submitted his motion. Jack Smith wants a jury questionnaire in the Florida case. This is the government's motion in the case of United States of America versus these three co-defendants. Obviously, Donald Trump at the top of the list, along with the other two. This is the classified documents case. And this is Jack Smith in a short filing asking for a written questionnaire to be completed in this case. They say, you know, the pretrial publicity in this case is pretty substantial, and the government wants a very thorough jury selection process, including a written questionnaire and so on. They say, you know, this is pretty common now, and it's going to make jury selection far more efficient as this moves through. Saying the government is mindful here that the court issued a prior order saying that apart from the date set forth and the date set forth for the calendar call and the trial, that any further deadlines will be set in March. So Judge Cannon told him, hey, shush for a little while, okay? I already scheduled the calendar. Don't put any more stuff on my calendar. But Jack Smith says, but we really want to go fast, Judge. However, given the lead time that the clerk's office will need to implement a jury questionnaire, beginning the process after March 1 will not give the court enough time, and we have to get Trump convicted like now. So as described below, previous cases in this district, we used questionnaires, and it took them 10 weeks to do this. And so we have to mail questionnaires to jurors, and then that has to be postmarked, and then that means a final questionnaire would need to be approved by March 11th for a May 20th trial date. And so they really want that trial date to stand. And we're also asking ourselves, that's probably going to move too. Now, as an alternative, the court could have the jurors summoned to the courthouse in advance. So if you don't want us to mail this stuff out, bring the jurors to the court and let them in here. And so for these reasons, the government moves the court for a new deadline. Add something to the calendar on February 2nd. Now, Trump is going to respond to this. He's not happy about it. The government has conferred with the defense counsel, and they oppose the motion because they think this is premature and this is not a good use of time. But the government disagrees. And so they say here, you know, a jury questionnaire is going to protect the defendant's rights. This is for Trump. We're doing this for Trump. We're going to make sure we have a fair questionnaire and a fair jury. In Sarnov, which was, I think, the Boston bombing guy, they used a 100-question juror form. In Skilling, an Enron executive, they used a 14-page questionnaire, and courts in other districts have used these as well. We can finalize these well in advance of trial, and for these reasons, Judge, we want you to do this. Let us use a jury questionnaire, and let's get this started now, because we got trial like in May. We want to get it finalized. So the parties submit here. They say, please set a new deadline, and then let us know where we can submit our questionnaire. Signed by J. Bratt, counselor to the illegally constituted special counsel's office, which is not even legitimate as an office under American law. So this was all submitted and sent in to the court. Now, Donald Trump responded to this, and he's not happy about it. He says, all right, look, we've got stuff on appeal. We're claiming presidential immunity. There's classified materials that we haven't even seen yet. We're tired of this. They say, guess what, Judge Cannon? President Trump respectfully submits this response, saying that Jack Smith wants to set a deadline. Well, frankly, the court should deny this most recent effort to set new deadlines outside of your schedule. And in addition to this, Judge Cannon, wasting the court's resources, this type of litigation also detracts from Trump's efforts to review all of the discovery and all of the other motions that are crucial to our defense. So stop interrupting us when we're preparing our defense. Therefore, President Trump respectfully asks that Judge Cannon order Jack Smith's illegitimate prosecution to refrain from further motion practice outside the existing schedule unless there are actually compelling circumstances, not just they want to race this case to trial. Saying, to be clear, in the event that the court does not dismiss this politically motivated election interference mission by the special counsel's office and the Biden administration, and the defendants, if you don't just voluntarily dismiss it on your own, Judge, we are going to submit multiple compelling bases for doing so, and we're going to do that in our motions, which are due in February 22nd. Now, if you don't dismiss it, then President Trump does not dispute that a questionnaire questionnaire may in fact be appropriate. Like, we might be okay with this. In connection with the trial where defendants will exonerate themselves. I love this bravado, man. I love it. Yeah, we could use a jury selection to have a trial where we will be acquitted. Happy to do that. But that is not manifestly what this motion is about. Apparently, Jack Smith believes that this case is governed by baseball rules. The office has taken another swing at maintaining the trial date that was set based on this office's, Jack Smith's, original misrepresentations regarding the timing and the nature of discovery. The court rejected their first attempt to do this. You remember, Judge, you said that deadlines and all other pretrial deadlines will start later. And in this motion, they claimed, based on, quote, experience and research, they ignored the court's prior use of the phrase. Jack Smith's office arrogantly purports to educate the court, Cannon. He's telling you about your logistics of jury selection in your Honor's own district as a pretext towards rushing towards an unjust trial. This motion is every bit as much as a whiff, and therefore strike two. The prosecution's purported concern about insufficient time to implement jury selection is illusory. It's based exclusively on partisan talismanic significance that they have assigned to May 20th. It's this anchor. There's no criminal reason for it, but they got to get it done before trial. If there could be any doubt about the true motivation behind the motion, it's obvious, though largely omitted from the motion, that such a questionnaire would need to give potential jurors a sense about when the trial would occur, and the court has already made that clear in March, saying any jury questionnaire would also have to estimate the length of the time of the trial. One necessary component of the estimate of the length of the case is going to be, the defense's case, because they're going to have to put on their evidence. And the length of the defense's case is going to rely on part about what discoverable material that they can get. So Jack Smith is going to have to give them information so that they know what their defense is, so that they can prepare the jurors for it, saying that it is necessary for the cross-examine of prosecution witnesses. And the court has noted the same. So the pretrial rulings will also be critical to additional key features of any jury questionnaires as well. We need a summary of the case. We need questions about improper biases. As we're still preparing our defense, we have not even reviewing all of the voluminous discovery. We've noted that there is important as of yet unproduced materials that we need, and Trump's pretrial motions are going to attack those aspects. For example, they say Trump's defense is going to bring to light important issues regarding the timing of Trump's security clearances, the timings of the FBI's illegal raid at Mar-a-Lago, the unlawful disregard of Trump's attorney-client privilege, other grand jury abuses, not to mention prosecutorial misconduct. Oh yes, selective prosecution, witness advocate problems, improper and unconstitutional involvement by the Biden administration and the National Archives, related abuses of the Presidential Records Act, the lack of sensitivity of certain documents, and flagrant overclassification of other materials. Now, that is to say nothing of the extensive SIPA litigation that is also going to be necessary, the time consuming before a fair trial can be conducted if one is necessary. If any of the pending charges survive these and other motions, and they should not, it will be incumbent upon you, Judge Cannon, and the remaining parties to administer jury selection procedures that are attentive to these particulars of this case. Any, quote, joint questionnaire proposed by February 2nd would not allow for us to do this inappropriately. So we would just be making up questions. Therefore, it would be a waste of time. Now, because the special counsel's office is demonstrably not committed to a just outcome in these proceedings, the office views the amount of work to be accomplished by the court and the defendants in litigating and resolving this, at most, a minor speed bump on the office's desired path of using Your Honor's courtroom for political advocacy. They are using your courtroom, Judge, to attack the leading candidate of the 2024 presidential election in a key state and beyond. And judges don't like when their courts are used as levers. And this happens not only in political cases, like if you try to go, if you're in the middle of a custody proceeding and you file a domestic violence claim against your spouse. It's like, okay, we know what you're doing here, and screw you. The prosecution has unapologetically misled the court from the start. For the second time in just over a month, Jack Smith have ignored the court's scheduling order in an effort to impose deadlines with no reasonable basis. And so Trump respectfully submits that this court should put an end to these improper filings and admonish Jack Smith, who's illegitimate, that future abuses that interrupt the defendant's discovery, review, and defense preparation will not be tolerated. And so for the foregoing reasons, President Trump respectfully submits that this court should deny the motion to set a deadline and submit jury questionnaires, and tell Jack Smith and his office that any further motion practice outside of this existing schedule, absent truly compelling circumstances, should not be done. And please refrain from bothering us while we're working. Sincerely, Todd Blanche and Christopher Keese, Trump's defense team. And so this is more fun stuff, and we expect Cannon to probably adhere to the schedule. Sorry, Jack, you're not on schedule. Get back on track. Jack. And of course, that case will continue to move forward as well. Now, some people are ignoring all of this, right? Nikki Haley is one of them, and she was out there almost giddy and gleeful that this stuff is happening, promising that as part of her run for presidency, she does not want to hear about any of this stuff. Trump stuff is outside the purview, and she's focusing on her and her alone. Forget the fact that the DOJ has been weaponized. Forget the fact that Trump has been indicted and they're trying to remove candidate from the ballots in various states. Doesn't care about any of that. Just wants to stay focused on winning.
Governor, nobody's going to vote for Nikki Haley because you said to vote for her. Maybe some people, but not a lot.
What kind of question is that?
In the midterms, a number of candidates you
Rude.
endorsed lost to much more Trump-centered candidates. I'm old enough to remember when your father endorsed George W. Bush in 2000 and McCain ended up winning by 18 points. So why is this going to be different?
We have 40 days. We're going to be out on the trail. We're going to be helping that grassroots support, helping build folks up. But right now, there's so many folks undecided. Everything's been delayed. A lot of the decisions won't be made really until the last couple of weeks. And in New Hampshire, it's all about results. So if you're results-driven, you want that efficiency in government, here's the path. Not just to get the Republican Party unified again, but the entire country. Give them a strong next generation of conservative leadership that everybody can get behind.
All right, come on.
And what I appreciate about Chris's endorsement, it's not a one and done. This, for the next 40 days, we're partners because we honestly believe we have a country to save, and we're determined to do it.
Let me ask you, speaking of Trump, he has claimed absolute immunity in his defense to the election interference case. Is that your view? Do you believe a president has absolute immunity for anything that happens while they're president?
I'm going to let the courts figure that out. I mean, the last thing you're going to see me do is weigh in or learn the details about any of his court cases because I can't follow 91 charges, and I'm not going to.
Total sense, but let me just ask you
Not really.
Principle. Forget his case.
So, Nikki, you're cool with the Democrats taking out right-sided candidates so that you can have a clear path to the nomination? Like, you're not concerned about the weaponization of our government against the political process? You're okay with 1.3 million Coloradans being thrown out of the political process because you can't keep track of it? Are you nuts?
Do you think that a president of the United States, that if you get elected president, you would have absolute immunity for anything you did while you were president?
That's not the standard, idiot. The standard is for official acts, which is what Trump was doing. It's not anything, okay? You can't go out and just start eliminating people.
I think the court issues are, do you have immunity when you're president, when you're not president? At what point does that line fall? I'm going to let judges decide that. I don't know where the line falls. President Trump's going to have to defend himself, no matter what. If he's found guilty, he's found guilty. If he's found innocent, he's found innocent. It would be wasted energy for me to sit there and focus on court cases and not focus on how to win that room that we just left.
Wild. So doesn't care, whatever. And if Trump does get convicted, if Trump does get thrown off the ballot, she'll be much happier about that because she'll be able to squeak into victory, right? These people are just disgusting. Like, why would you want to win by having your top opponent taken off the ballot? Because you can't win on your own, and that is weak and pathetic. Now, even this guy, Bill Barr, who is not a Trump fan, is recognizing that this stuff is problematic, saying Colorado's not a good one. Here's Bill Barr.
The core problem here is the denial of due process. To deprive somebody of the right to hold public office requires due process. It requires an adjudication of two core issues. One, was there an insurrection? Did the public disturbance rise to the level of an insurrection? And second, what was the role of the individual in there? Was it engagement? Did they do something to break their oath of office? Those are complicated facts, and this was denied due process. It was a 5-day hearing. There was no jury. It was before the judge. We're not able to subpoena witnesses and compel the attendance of witnesses. They relied on, the hearings, the January 6th committee hearings, which is mostly hearsay. There was no right to cross-examine during those hearings and so forth. As the dissent said, and by the way, the 3 Democratic justices who dissented, their opinions, I think, are masterful. And as they pointed out, they said, the process here was a procedural Frankenstein.
Yeah. They had one mission, which was to get rid of Trump. And you know what? It worked out. And the people who are formulating these plans, they are not done yet, my friends. Now, they are going to continue to try this stuff. They are freaked out, but we are seeing some very good progress being made in the courts. We're knocking at the door at the Supreme Court. We've got Trump's team looking like they're firing on all cylinders, objecting to different jury questionnaires, submitting briefs to the Supreme Court. And now we have an idea that Jack Smith might be illegitimate in the beginning. So we are going to be covering all of this and more, my friends. There is a lot of Trump trials to follow out there. And so hopefully you're inviting a friend or family member to come and join you and join us when we cover this stuff here. We'd love it if you subscribe to our channel. We'd love it if you went over to robertgovea.com and got a brand new Watcher hat. And we'll look forward to seeing you on the next one.